ability to establish somebody to make healthcare decisions for them, or somebody to pay your bills, or somebody to apply for government benefits or insurance or whatever the case may be. So guardianship is now likely going to be necessary, all right? So let's talk about a couple of the basics. Guardianship has to be last resort. There can't be anything known as a less restrictive alternative. And that's typically a power of attorney or a healthcare surrogate document. If we'll go over some scenarios where there might be a power of attorney, but you still need a guardian. But if those less restrictive alternatives exist, then you have to have a really compelling reason why a guardianship is going to be necessary, because guardianships take away all rights of your resident, right? We talked about the power of attorney. Well, your power of attorney can give your principal can give someone the power of attorney, and they can become the agent, but the principal still retains all of the rights to make their own decisions, do whatever they would like. That does not happen once a guardianship is in place. So these are only used also when residents are incapacitated. Now that is, incapacitated is a legal term that exists in the guardianship world, but it basically means they are incompetent. They can't understand, they don't understand the implications of the decisions that they're making. And I'll go over how that's determined in a moment here. Public guardians. Now, public guardians in Florida are used only when your resident is indigent and they have incredibly long waiting lists. And you maybe have experienced that already. In fact, several of the public guardians around the state aren't even taking new cases. So you can say my resident is incapacitated, my resident is indigent, and their response will be, great, we'll get to you in 6 months. Once we've got 25 people on the waiting list ahead of them, and we'll see what happens when we get there. So that's why professional guardians that are going to become is a growing area of this world. Family members can serve as guardians. Friends can serve as guardians, but they have to take a course on guardianship that's offered by the state, and they have to pass a criminal background check. So that has to be made clear to everyone. A lot of people say, well, I'd love to be the guardian if we need that, and then they find out, okay, well, you got to take a course, you got to pass a criminal background check, and you're going to have to handle the bills for all of this. And then all of a sudden they're not so interested anymore. So we have the professional guardian option. Professional guardians, again, are usually going to be your best option because the public guardians are just so backed up, and a lot of times you're not going to have willing family or friends to do it. There is guardianships in all cases are very stringently overseen by the courts, and the benefit to you using a professional guardian is that they will work in cooperation with you. They know why they're being brought in. They're being brought in to help you establish payer sources or healthcare decision making or whatever. Family members, again, they always like the idea, I want to do it. I don't want some professional that I don't know coming in and taking care of mom, but then you tell them, okay, well, you can cover the cost of doing all of that and take the test and everything, and they a lot of times lose interest. Here's a good one. If the family member didn't do what they were supposed to do as the agent under a power of attorney, you don't really want them to be the guardian, okay? Because they're just going to keep doing their bad habits. So we see that a lot. There's a lot of times in our cases we see that there is somebody, a family member, that holds the power of attorney, but they took off with mom's paycheck, or didn't make decisions, or you can't get a hold of them anymore, or they've disappeared, and then we have to explain to the court why, well, there is a less restrictive alternative here in the form of a power of attorney, but that person's gone. They've disappeared, we can't rely on them anymore, so hence we need to overcome that less restrictive alternative and go ahead with a guardianship. And in estate planning, like maybe, I don't know if Beth, in your world, any of your forms have a portion to fill out if you want to name a pre-need guardian, right? So while they still have full capacity, they'll say, all right, I want my daughter to be my power of attorney, but then if I become incapacitated and we need a guardian, I would like somebody else to be the guardian. They can name them, and then those wishes have to be followed. So how does the nuts and bolts of guardianship work? Well, once you've determined that your resident is incapacitated, you file the petitions to appoint a guardian and a petition to determine incapacity. The court appoints 3 professionals to come out to your community and interview your resident. They're called the examining committee. And they'll come out, they'll interview, they'll make an assessment of what is this person really has capacity or does not, and then they'll file reports. And then that's what the court uses to determine whether they have become incapacitated and can qualify for a guardianship. Now, these are the rights that are subject to being taken away upon a finding of incapacity. The right to contract, the right to marry, the right to vote, the right to seek or retain employment, the right to obtain a driver's license and operate a vehicle, sue and defend lawsuits, apply for government benefits, manage property or make gifts or dispositions of property, determine residence, consent to treatment, and make decisions generally about their medical or social environment. In 99% of all cases, all of these rights are going to be removed because it's really difficult to say, well, and an exam committee member will generally not ever say, I think Mr. Smith has the ability to contract, but they don't have the ability to vote. That doesn't really make any sense, right? So it's usually all of these rights that are going to be revoked. Now, there are 2 types of guardians. There are plenary guardians, which have total responsibility for the person making all healthcare decisions and the property, which means filing for government benefits or disposing of property, closing bank accounts, etc. Or they can be limited. And limited can be limited to a variety of different things. It might only be for healthcare decisions, but they feel like maybe the resident has some capacity to still sort of make financial types of decisions. Probably would be in the reverse in most cases. But again, the vast majority, 99% of all cases that I've seen, are full plenary guardianships. All rights are being removed. Now let's say that the professional guardian is your only option, right? So who is going to pay for those costs? Well, initially, you are, all right? In the practical world, you are, all right? So you're going to pay the cost to establish the guardianship and then the cost for continuing on with the guardianship. And I threw in some kind of rough ideas about what all this costs, right? So you're filing a petition to appoint a guardian and a petition to determine incapacity at the same time. Each one of those is about $500, so $1,000 for the hard cost of filing for the case, right? And then the exam committee, all 3 of the exam committee members have to be compensated. They're professionals. One has to be a doctor. I think one has to have some sort of psychological psychiatrist or something like that background. And then the other can be a lay person. But they all get paid for that service. And it's roughly about $300, $350, something like that for all of them. So for $1,000 or so, that covers all 3. And then also the court will appoint an attorney to represent your alleged incapacitated person during the pendency of the guardianship proceedings, right? So up until the point that they are determined to be incapacitated, they still retain the right to make all of their own decisions, and so the court will appoint an attorney for them, and he will make sure that all their rights are being protected during the initial part of these petitions. And that just